So we turn your phone off.
Good evening, everybody. It's John here from Tutor to You, welcoming you along to the first in a new series of revision blasts and revision clinics for A-level law. Massive and warm welcome to you if you are joining us live. It's lovely to see you. I'm just looking down at my little clock down here and my chat window, which I've got available to me here. It's great to see so many live people joining us. If you've not been to one of these before, either for this subject or any others, what we've got is about 30 minutes of fast-paced activities. Tonight, of course, we are concentrating on contract law. We're going to throw a load of questions at you, and what we would love to see are some of your responses back. So please do use the chat window in YouTube if you have that facility. Now, I'm joined tonight by the real experts. I've got Liz on the left-hand side of the screen and Gemma on the right-hand side. Good evening to you both.
Hiya.
Wonderful, great stuff. So what we're going to use is a little PowerPoint presentation to deliver the questions. At the end of this live session, as soon as I've pressed the finish button, that PowerPoint will become available. So you can always download it if you want to go through some of the questions again. And of course, this is being recorded. So if you do want to take a little bit more time, then you can do so. And if you're watching this as a recording, welcome to you as well. You can take a bit more time over answering some of those questions. Introductions done. I think shall we get started?
Sounds great.
There we go.
Okay, so I am going to be taking you through the first three activities. Then we are going to be passing over to Gemma. So the first activity is called the big reveal. So you need to work out what is hidden underneath the question mark. And in order to work that out, we are going to provide you with a number of clues. So clue number one. Okay, it reads, I am a topic within formation. So you can start now thinking about all of the different aspects of formation. So the topic which looks at how contracts are made. So any ideas that you've got for formation, you can start popping those in the chat. If you work it out by the first one, I will be very, very impressed. There are lots and lots of topics within formation. So it is quite a broad, vast topic. So there are lots of different options there. Okay, so we'll reveal clue number 2. Oh, okay. So this gives us a lot more information and really narrows down the possible areas, the possible topics this could be. So I do not create an agreement. So agreement is a topic within formation. Agreement is the offer and the acceptance. And there are lots and lots of different principles about offer and acceptance, but we know that this does not create an agreement. So if you can think of any areas within contract law that don't create an agreement, you can pop those in the chat. Okay, so if we reveal number 3, clue number 3. Oh, so somebody has said privity. Okay, so that's a good suggestion. Privity of contract is a topic which generally kind of sits within that formation area, but privity is a concept that applies to the enforcement of contracts rather than something that doesn't create an agreement. So, but thank you for having a go. Any other ideas, pop in. So our third clue is I end an offer. Okay, so Elena said invitation to treat. That is a topic within agreement, within formation, so well done. And it's really important to distinguish between an invitation to treat and an offer. But an invitation to treat isn't strictly something that ends an offer. So Sarah has said consideration. Also a really big important topic within formation, lots of different principles, but it's not something that ends an offer, it's distinct. Lucy has said rejection. This isn't rejection, but that's a correct possible answer based upon these clues, so well done. There are lots of different things that will end an offer. An offer will not remain open forever. That's not reasonably practical because, you know, the person making the offeror, might not want an offer to remain open forever. So rejection does end an offer. So if somebody, you know, makes you an offer and you say, no, I don't agree with those terms, and then later on you think, actually, maybe that is, maybe I do want to accept that offer's still not there. Okay, so we'll reveal clue number 4. I am a very common response to an offer. Okay, so lots of different things that will end an offer. This is quite a common response, so I think somebody might be along the right lines here. We will reveal clue number 5. And I propose alternate contractual terms. Somebody has said acceptance. Acceptance, a couple of people have said acceptance. Acceptance does also, it can end an offer, but it's not quite that. A couple of people have started to work out what we are talking about. So well done if you have worked that out. So we can reveal that the answer is counter offer. Well done. So a counter offer is when somebody proposes alternate contractual terms in response to an offer that they've been made. So you've got party A and party B. Party A makes an offer, you know, a proposal of terms upon which they wish to contract. And party B says, okay, I would agree to those terms with this alteration or this amendment and this addition. And actually, unless the acceptance is complete acceptance of the offer, any proposal of an amendment is a counter offer. So a counter offer ends an original offer. Now that's really, really important because negotiating is, you know, and kind of proposing different terms is all part of that formation process. But it's really, really important to remember that, you know, if you reject an offer, so if you're, you know, you're looking at a car that's for sale for £1,000 and the car dealer or the private person selling it to you says, you know, I'd sell you this car for £1,000, and you then say, okay, I will buy it off you for £1,000, but I would like it to have a full tank of diesel or petrol. That additional element makes it a counter offer, and that counter offer destroys the original offer. So then actually the counter offer made becomes the main offer that then can be accepted by the other party. If they say no, you can't then go back and say, oh, okay, I'll have it for £1,000. They would need to remake that offer. So lots of you got that in the chat, so super well done. We will move on to the next activity. So our next activity is a categorise activity. So you will see across the top here, across the top of this table, you've got 3 of the 4 key contract law topics. So what is really nice about contract law, and if those of you that have joined us this evening are anything like my students, contract law is probably your least favourite topic. The beauty of contract law is that actually the amount of substantive law that you need to know is a lot less in comparison with tort law and with criminal law. So there's 4 key substantive topics. You've got formation, discharge, terms, vitiating factors, and then remedies. So what you've got to do here, and you're going to have 60 seconds to do it, is all of each of the boxes which are numbered underneath have topics, and you need to work out which category they sit within. Okay, so you don't need to write all of the words out again into the chat. You just need to say formation, 3 letters, discharge, 3 letters, etc. Okay, so we will press the button and start the timer. Okay, so you've got 60 seconds to put these boxes, these topics, into one of the 3 categories. So the mathematicians amongst you might have worked out that 2 are going to have 3, and 1 of them is going to have 2. So pop the topic and the topic area and then the numbers into the chat. Okay, so we've got about 20 seconds that are left. People are popping them in the chat. Good work. Yeah, nearly there. Good work. There's lots of comments which are coming in, which is great. Okay, well done. So that's lots of thinking and processing to do in 60 seconds, especially with the music, the suspense building up. We will reveal the answers on the next slide. And that is how the topics are categorized. Lots of you have got that in the chat correct, so really, really well done. So formation, those are the 3 key elements of formation. In order to have a legally enforceable contract, you have to have acceptance of an offer, and that is collectively known as agreement, consideration, and intention to create legal relations. You need all 3 aspects. If one of them is not present, there might still be an agreement, but it's not a contract. It's not a legally enforceable agreement. And all the examples, whatever example it is you're studying, they are going to have problem questions, which are scenario based. And if you have got a scenario which has got lots of different stages of negotiation, so, Amal said to Ben, would you like to buy this? Ben said, I don't know. So Amal offered it to somebody else and Claire said she wanted to buy it, for example. If you have a scenario which has got lots of different stages of negotiation in, that's indicating to you that you are going to be discussing formation. So well done to those of you that identified for discharge. That is breach, frustration and performance. So discharge refers to how the obligations within a contract are discharged, how they're ended, and they can be ended via a breach, a failure to perform your contractual obligations adequately or at all, via frustration or performance. And lastly, the final 2 topics in terms, you've got exclusion clauses, which is a really important topic, and then the Consumer Rights Act, which is a really big topic and likely will come up in exam papers somewhere, about the terms that are implied into contracts between traders and consumers. So we will move on to the next activity. So this is the Chile quiz. So you are going to have 3 questions about contract law on the next page, and the questions will increase in severity, in heat, according to how many chilies they've got. So you've only got 30 seconds. This is no really kind of quick fire. Pop your answers into the chat, numbered 1, 2, 3. Off you go. So I've got some different music here, which is very nice. So this is really, really quick, and they do increase in severity as you work your way through. So if you're finding question 3 a bit harder, that's deliberate. Okay, so some people are starting to put answers in. Well done. So this is drawing on a range of topics within contract law. Okay, so that was your 30 seconds. Well done if you have got your answers in. Okay, so we will reveal the answers. So question number 1, what must performance be to be valid? So this is relating to the topic of discharge, and that in order for performance not to be potentially a breach, it must be complete and exact. It must completely and exactly, it's called the mirror image rule sometimes, it must completely and exactly reflect the obligations. So lots of people have put in there, it must be mirror image of the terms. Well done. Complete and exact, a few people have said, so very well done. So the Consumer Rights Act, really, really important that you know there are 2 lots of terms that are implied into contracts. 1 lot of terms for the sale of goods from trader to consumer, 1 lot for the supply of service. So which section of the Consumer Rights Act says goods should be of satisfactory quality? That is section 9. So super well done to those of you that have got that. It is really hard learning topics that have got multiple different section numbers. The higher the marks you want to achieve in the exam, the more information you need to know about that provision. If you actually look at the statute, there is a lot of guidance about what kind of characteristics and what factors will affect what is considered satisfactory. The more information you know about that, the more application you can get about those terms within an application question, the better. So, thirdly, the hot question. This is really tough. So how is executed consideration different to past consideration? So past consideration is one of the principles of consideration that you will learn. And past consideration is not valid. Past consideration is not valid consideration. And past consideration is an act of consideration. It's something of value that is performed before there is any pre-existing contractual relationship, any negotiation, any indication whatsoever that there is going to be a contractual relationship. So it's if somebody got home and their partner had, I know that'd be social and domestic anyway, but their partner had cleaned out their car for them, and then their partner said, oh, that's amazing, I'll give you £30. So that offer of the money is in relation to something which is completed, something that is passed, something that is done. That is not valid consideration. Executed consideration, conversely, is valid consideration, and executed consideration is consideration that is performed upon the basis in order to enter into the contract. So executed consideration is something performed with contractual negotiations in mind, although they might not have been definitively agreed yet. So, for example, if I had lost my cat and I put up a reward poster and said, if you return my cat, I'll give you £500. I really love my cat, obviously. And the person, whoever finds the cat, turns up back with the cat. That is their acceptance of the offer and their consideration being performed simultaneously. So at the point when they're accepting it, it's already executed. But that's distinct from past consideration because it is executed in response to the offer. So really well done if you got that right. Okay, so that is me done. And I will pass you over to Gemma for the next 3 activities.
Hi everybody. Okay, so we're starting with the bubble quiz. So there's going to be a question and you have to identify the correct answers. The number of answers can range from 0 to all 4. So type in the chat box whether it's A, B, C or D. So this first question, which of the following are vitiating factors? So type in the chat box A, B, C or D. Maybe a combination of a few of those. Which of those are vitiating factors? Remember, a vitiating factor makes a contract voidable. I think we're already getting some answers in here. Yes, well done. We have 2 vitiating factors in your specifications. They are economic duress. You can bring some of your knowledge, should know what addresses from criminal law, and of course misrepresentation, a false statement of fact which induces another party to enter into a contract. Okay, brilliant. And question 2, let's have a look at that. When could a vitiating factor not occur? A bit different, this one. Those of you on the AQA spec, you will have some multiple choice questions, and you must take care when reading those, because sometimes you're asked when something is a negative when it can't be. So you've got to take care when reading those. So let's have a look. When could a vitiating factor not occur? A few people coming in with a few answers. There's people coming in with more than one correct answer here. Let's have a look. Let's have a look at the answer. When could a vitiating factor not occur? So it couldn't occur at the time of expected performance. It couldn't occur during a court claim because that would have to be after, and of course after the agreement is made. So a vitiating factor could not occur in those 3 instances. We have got some people who've got those correct. So well done. Quite a difficult question, that one. Okay. Third question we'll go on to. So we're now looking at misrepresentation, and there are different types of misrepresentation, and you do need to state in your answer, if it's a misrepresentation question, which type it is, because that is relevant for the remedies. Okay, so which of the following is not a type of misrepresentation? We're already getting some answers in here. It could be more than one correct answer. Let's have a look at the answer. Let's reveal. Yes, so those 2 are not types of misrepresentation, because of course misrepresentation can be negligent, innocent, or fraudulent. So your answers there are B and D. Those have been made up. Okay, question 4. Which of the following is not an element of misrepresentation? So I think I did go through, briefly mentioned it before about misrepresentations, so if you were listening. So what elements have we got to have for a misrepresentation? So which of those would not occur in an answer about misrepresentation? We're already getting some correct answers in, which is good. Seeing some answers in. Well done. You've obviously been revising these vitiating factors. Let's reveal the answer. Let's see if we've got them correct. Of course, yes, it is C and D, because misrepresentation is a false statement of fact made by a party to the contract to induce the other party to enter into it. Well done. Well done on that. Okay, so our next activity. Okay, so this is quite an easy activity, but I'm going to throw in a little question at the end in relation to one of these questions, so watch out for that. So each of the key phrases shown on the next slide, so we have the vowels changed to an alternative vowel. So can you work out the key phrase? You should be able to do this quite quickly. So we've had some vowels change there. So what is the correct word that we would be looking at here? Importance in contracts law. So what would we change some of those vowels to? Type your answers in the chat box. Yeah, we're getting some answers in. Well done. It is, of course, agreement. Fantastic. Okay, go on to the second one. I don't know if that just revealed then. I'm not sure. But
it did reveal that. That was my fault. Sorry.
I think somebody was a bit. Somebody got carried away there, didn't you, John? Okay, so yes, type it in. I think we know what the answer is, though. I think we have a sneaky look there. Representation, fantastic. And then the last one. Some of the vowels been changed to there. Type it in the chat box. Yes, we're getting the answers. Consumer, right, I'm going to ask you an extra question here because Liz has already mentioned twice, I think, that the Consumer Rights Act 2015 is really important and can come into a variety of different scenario questions, particularly And it is a really important piece of legislation as well, giving consumers those rights and trying to put them onto more of an equal footing with a trader. Okay, so in the Consumer Rights Act 2015, we have 3 very important sections, okay, that you'll probably have learned to start with, which give some rights in relation to goods and state that goods should be certain things. Okay, so what does Section 9, Section 10, and Section 11 state in relation to goods? Can we type in the chat box? So I'm looking for what Section 9 of the Consumer Rights Act says, what Section 10 of the Consumer Rights Act says, and what Section 11 says. Okay, you do need to know these sections, and there's more than just those 3 sections that you need to know. You need to know quite a few, because you need to know just not necessarily what the rights it gives, but also the remedies that it gives. So we're getting some answers in. Yes. I think I'm trying to read them through, but I think everybody is getting a lot of those right. So Section 9 says that the goods must be of satisfactory quality. Section 10 says that they must be fit for purpose. So if you buy some waterproof trousers, okay, then they have to be waterproof, not let the water in, okay? And Section 11, they have to be as described. So if something is described as being a blue dress, then it should arrive and it should be blue. It shouldn't be red, for example. So those are 3 key sections. And of course, then you need to know the sections that gives them remedies as well, okay? Well done. Okay, little extra question added in there for you. Okay, let's move on to the last activity, 30-second challenge. Okay, you are going to be typing at a rate with this, because it's quite a big question. Okay, so let's go, let's reveal. List as many formation cases as you can think of. Go, guys. Okay, this is a big topic, okay? So formation, probably the first aspect of contract law that you'll have learnt, and it covers offer, acceptance, intention to create legal relations. There's so many cases that you could have put in there. Somebody in there, we've got some lists there. I've got there, AM has put Carlisle and Carbolic Smokeball Company. That might have been one of the first cases that you covered. Of course, very important case there concerning a unilateral offer. We've got some there in relation to invitation to treat. I think somebody had put in Partridge and Crittenden there. There's also, I'm sure I'd seen Fisher and Bell. So yes, somebody else, a case that I really like as well, somebody's put in here about Feldhaus and Bindley, about how you can't have acceptance through silence. You've got to cover things such as counter offer as well, which Liz has already spoken about, and you might have covered cases such as Harvey and Facey about requests for further information. You might have looked at a variety of different cases. You might have looked at lapse of time. I don't think anybody's put this one on. I'm not sure. I haven't seen it. Lapse of time about, Liz talked about how long an offer stays open for, and it can't stay open for an indefinite amount of time. So you might have done a case there concerning a hotel. Anybody knows that? So if you can type it in the chat box. One last question. Yeah, we've got it up there. Somebody's done it. Well done. So Ramsgate Victoria Hotel and Montefiore. Yes. And talking about how long is a reasonable amount of time for something to be kept open for. Well done, the people who got that last question that I just slipped in there. Okay, so well done to everybody for engaging, and I hope you found that useful.
Some really good responses, particularly with that open-ended question towards the end there. Lovely stuff, and hopefully people have found that really valuable. Just a reminder that the PowerPoint that Liz and Gemma have been using will be available to download in just a minute's time, and you can watch through this again. If you found tonight useful, please do give us a thumbs up in YouTube. That helps us get our message out there. Thank you to everybody who has actually given us some responses tonight, and of course a massive thank you to Liz and Gemma for going through each of those questions. You'll be back with us on another date. I'm right, aren't I? You're not with us later on tonight, but you are back with us at a future time. And so we're coming to an end of this session, but we have got another one coming up very, very soon, starting at 7 o'clock. So in just half an hour's time, we'll be looking at human rights. So if you're covering human rights as well, please do join us in about half an hour's time. But until then, until we see you again, thank you to everybody and a very good evening. Goodbye, everybody.